Hello, everyone, and thank you for attending today's webinar. My name is Taylor Dawson, and I am a litigation attorney here at Beresford Booth. Today, we will be discussing and reviewing a property law doctrine and concept that many of you are likely familiar with. Adverse possession is a common law doctrine that frequently arises in boundary and property line disputes and lawsuits. It is a somewhat archaic doctrine that can enable a non-owner of property to obtain lawful title to property they otherwise would not own if they are able to satisfy the requisite elements. Claims for adverse possession often arise in the context of disputes between residential property owners, such as neighbors, but can arise in other circumstances as well. Washington State has established four separate elements that claimants must satisfy in order to prevail on a claim for adverse possession and obtain title to property that they otherwise did not purchase or would not own. Included with this slide is just a brief overview and agenda regarding the topics of discussion and issues to address and consider during today's webinar. Under the adverse possession doctrine, a possessor of land may gain title to property from the true owner by adverse possession if four conditions are met. The claimant's possession must be 1, exclusive, 2, actual and uninterrupted, 3, open and notorious, and 4, hostile. A person asserting a claim for ownership through adverse possession must establish each of these elements for a period of at least 10 years in order to prevail on an adverse possession claim. However, under RCW 728070, the 10-year period required for adverse possession claims can be reduced to 7 years if the claimant pays the property taxes associated with the disputed portion of property as part of the taxes assessed against their property for a 7-year period. The doctrine could be encapsulated in one understandable sentence. Possession is adverse when the claimant possesses the property for 10 years as the true owner would and asks no permission for such use. Although these terms and concepts may seem simple enough upon initial review, the reality is that there is significant ambiguity and room for interpretation as well as argument in determining whether a claimant has satisfied each of the elements on a claim for adverse possession. Arguments regarding whether one or more of these elements have been satisfied often result in protracted disputes regarding whether a claimant has established one or all of these elements in a particular case. It is important for property owners to be aware of the underlying rationale and practical implications associated with adverse possession claims, which can significantly affect property ownership as well as owners' rights and interests. Included in this webinar are how courts throughout Washington have defined and interpreted these terms, as well as factors and criteria that courts consider and evaluate in ruling on claims for adverse possession. The first element to address are the exclusive and actual and uninterrupted elements. The term exclusive for purposes of adverse possession only means exclusive to the extent one would expect of a titled property owner under the circumstances. Actual possession is the exercise of dominion over the land in a manner consistent with actions a true owner would take. Exclusive is defined similarly to actual, despite exclusive being an element distinct from actual. Exclusive possession denotes acts indicative of true ownership during the statutory period. In order to be exclusive for purposes of adverse possession, the claimant's possession need not be absolutely exclusive, but the possession must be of a type that would be expected of an owner under the circumstances. The second element to address is the open and notorious element. Notorious possession, as applied to the adverse holding of land, means only that the claimant's claim of ownership is evidenced by such acts and conduct sufficient to put a man of ordinary prudence on notice of the fact that the land in question is held by the claimant as his own. Open has many definitions, but the meaning befitting adverse possession is completely free from concealment, exposed to general or particular perception or knowledge. The open and notorious requirement is met if 1. True owner has actual notice of the adverse use throughout the statutory period, or 2. The claimant uses the land so that any reasonable person would assume that the claimant is the owner. No Washington case distinguishes between notorious and open. The third element to address is the hostility or claim of right element. The hostility and claim of right element of adverse possession requires only that the claimant treat the land as his own, as against the world throughout the statutory period. Hostility is not personal animosity or adversarial intent, but connotes that the claimant's use has been akin to that of an owner. Maintenance of a structure partially on the land of another, such as a fence, almost necessarily is exclusive, actual and uninterrupted, open and notorious, and hostile, and made under a claim of right. Included in this webinar is a brief discussion of some illustrative cases that address and elaborate on some key holdings, principles, and caveats practitioners should be aware of in handling adverse possession cases and claims. The cases are addressed in chronological order. In Huff v. Northern Pacific Railroad Company, a 1951 case, which is technically a prescriptive easement case and not an adverse possession case or claim, but which is cited as authoritative in subsequent adverse possession cases, the Washington Supreme Court held that 1. Where a non-owner or claimant's entry has been adverse and hostile, its character as such cannot be interrupted or destroyed by the property owner's unsought consent. And 2. To interrupt or disrupt the continuity element of adverse possession, there must be actual cessation of the possession. Mere protest or objection will not interrupt possession that is hostile at its inception. In Chaplin v. Sanders, a 1984 case, the Washington Supreme Court held that 1. A land possessor's subjective belief regarding whether the land possessed is or is not his own and his intent to dispossess or not possess another are irrelevant to a finding of hostility. And 2. When the true title owner knows of the possessor's adverse use throughout the duration of the statutory period, the element of open and notorious is satisfied. In Lingvalb v. Bartmess, a 1999 case, the Washington Court of Appeals for Division 2 held that 1. Claiming, maintaining, and occupying land around planted flora, such as trees, is evidence of hostility and may be sufficient to satisfy the hostility element of an adverse possession claim. And 2. What constitutes possession or occupancy for purposes of adverse possession necessarily depends to a great extent upon the nature, character, and locality of the property involved and the uses to which it is ordinarily adapted or applied. And finally, in LeBleu v. Ailgard, a 2016 case, the Washington Court of Appeals for Division 3 held that 1. In determining whether a person has acquired title to real property through adverse possession, the fact that he or she was given permission to occupy the land by the true title owner will operate to negate the essential element of hostility. 2. In the case of a failed parole or oral agreement, To adjust the boundary line, the fact that the true title owner agreed that his neighbor would own whatever land fell on the neighbor's side of the agreed line does not negate the element of hostility. And three, parties can agree to a non-owner's use of land that is adverse. In summary and conclusion, claims for adverse possession, as well as the interpretation and determination of whether one or more elements of a claim for adverse possession have been satisfied, can be difficult and complicated. The elements and terms comprising this doctrine are fact and circumstance dependent and can be equivocal or nebulous. Accordingly, it is important to consult with an attorney if you believe you may have or have to defend against an adverse possession claim. If you have questions about adverse possession, please feel free to contact the lawyers at Beresford Booth. Thank you, everyone.